Good afternoon, Columbus Realtors. I am Brent Swander. I am your Columbus Realtors CEO, and I am joined today by our 2024 Executive Committee, 2024 President Scott Rabchek, 2024 President-elect Buffy Patterson, and 2024 Secretary Jeremy Pape. Our Treasurer, Gloria Alonzo Cannon, had a pre-scheduled activity or event that she scheduled months ago and was unable to join us today. We are pleased to be here today. Again, this is our second one to provide another update as we're just hours actually away, one day away from the NAR Settlement changes here at Columbus Realtors and the MLS. We know there are a lot of questions, some anxiety, frustration, and yes, even some anger. But we're here for you. We're here to support our members to the best of our ability. And Scott's going to dive a little bit deeper into that here in a second. I just want to begin by opening up and saying thank you. Thank you to our members who believe in us, your Columbus Realtors, the association, our leadership team, and what we do to provide value to you on a daily basis. I believe Columbus Realtors is a premier organization, and we're only just beginning. Actually, several weeks ago, we had a group of my peer CEOs in Columbus evaluating our operations, and transparently, it could not have gone better. And no, I'm not just saying that. It's easy for me to say, but that can be verified by our leadership team who had some conversations with them as well. However, we do have some decisions about where we as an association and MLS want to go and who we want to be. Investing in our team, our products, our services, technology, and continuing to serve our members must be a priority. This industry is changing and changing quickly. We must adapt and we must think differently. I'm pleased to have the opportunity to work alongside an incredible executive committee and leadership team who I truly view as partners in what we do to support you, our members. Thank you for your support and, more importantly, the support of our staff and all of our members. We mentioned this before, but we knew that in 2019, when the first lawsuits were brought, we were probably 4 to 6 years away from the question being, what happens next? Where are we going to go? Well, as we've talked about, we're now here. We are entering a new era of organized real estate, and Columbus Realtors is here to support you. Before I turn it over to Scott, I want to promise and acknowledge several key items. First, we as staff are going to be figuring out these changes as we begin implementation just like you are. Several associations and MLSs implemented these changes earlier this month to prepare for the August 17th, the Saturday deadline, but our board felt strongly to avoid confusion on dates. Let's implement as close to August 17th as possible. Hey, we're going to have a few bumps in the road. We're figuring it out as well. I think some of you might have even gotten a few inadvertent emails from Flex earlier this week, and for that we apologize. This isn't a perfect process, but our staff is dedicated to customer service. You're going to hear me talk a lot about customer service. You, the members, are our customer, and we take that very seriously. Scott, I'm going to turn it over to you.
Thank you, Brent. First off, thank you all for joining us on this webinar today. It's a lot of important information that we need to share with you, and we just appreciate you being on this webinar. I want to take a moment to thank Brent and his entire team. Over the last few weeks, the pressure has been building. There is no denying it. And as you mentioned, we've had a lot of questions that have come in, and they are being directed at leadership and at staff here at Columbus Realtors. And I want to remind everybody watching today that the answers to a lot of those questions actually end up being brokerage or business related. Columbus Realtors has 2 specific charges headed into tomorrow. Eliminating offers of compensation from the MLS, number 1, and then enforcing buyer rep agreements, which will soon become state law. Now that we've covered that, here's a brief outline of what we hope to accomplish today. First, we would like to make sure that you are informed of the changes that will be implemented tomorrow morning. Highlight our forms and educational resources moving forward, and discuss some questions that the memberships submitted before this webinar. So let's begin with item number 1 of the change being made tomorrow morning. Beginning right around 8:30 a.m., all compensation fields will be removed from the add edit function within the MLS. At that point, there will not be any ability to add or edit compensation as you currently know it. Immediately after those fields have been removed, compensation fields will have been removed from all active listings. This process will take several hours. By roughly noon, all active listings will have those listing fields removed. So tomorrow morning, there might be situations where you see compensation on some listings and not on others. As of 8:30 a.m., there is no unilateral offer of compensation in the MLS.
Thanks, Scott. I think that's incredibly important, that timing, that 8:30 a.m. tomorrow, roughly. We're relying on humans to start this process, so roughly around 8:30 is when we'll begin that entire process. We're going to address some additional questions regarding compensation, concessions, etc. here shortly. However, one thing that I want to do to get things started is to go through the panel and get the current take from each of you as how you feel prepared and what you've done to prepare for the changes that are taking place. What guidance can you give the members watching today? I want to start with Buffy and Jeremy. Buffy and Jeremy are both brokers. So as brokers, how have you taken steps to not only become prepared, but to train your agents? And quite frankly, how are you feeling? Buffy, let's start with you.
I feel pretty good. Actually, how I prepared myself was by going out and really just soaking up all the information provided on the NAR website. You could go out to facts.realtor or competition.realtor and get tons of information. There are some wonderful FAQs out there as well. In terms of how we prepared the brokerage, really from the announcement in October, we started trainings. We implemented a mandatory use of buyer representation agreements early. We started that on March 1st. And we've just continued to have trainings. I actually did a training today prior to this webinar with our brokerage. And additionally, some of our agents kind of took on the charge, and they've been working together to do role plays and masterminds to ensure that they are prepared for what is about to occur.
Thanks, Buffy. Same thing, just to echo on what she said. We've been working on this for quite a long time. But we have just a tremendous amount of trainings that we're doing in our company. We had a company meeting going over this exact same thing today, right before here. We had to rush right over here after that. But we're doing 2 a week right now to make sure that everybody gets trained on this, whether it's virtual or in person. We're doing role playing. So we're just trying to keep up with all the changes.
You got some pretty awesome social media things going on.
Yeah, we
as
try
well.
to keep social media going, let people know through that way too.
Good. Scott, you're the commercial practitioner of the group, so this doesn't really impact what you do on a day-to-day basis. Quite frankly, you're actually even kind of used to it. There is there isn't an MLS in commercial world. We've talked about this in our last webinar. That quite frankly, there are some commercial practitioners who are paying somewhere of maybe north of a couple grand a month for inaccurate databases or maybe some splintered information found in disparate sources compared to what we charge on a yearly basis of a couple $100 for the MLS for arguably very accurate information. How can the commercial real estate serve as an example for what residential agents are about to go through?
Yeah, and I think we covered this a little bit in the last webinar that we had. And this has been a standard of practice in the commercial real estate industry my entire career. And I think the things that we try to make sure we are incredibly focused on is making sure we can articulate our value proposition to those clients that we represent. And also making sure we understand, that they understand what our role and responsibility is, and frankly, what their role and responsibility is. And I think your opportunity to do that with your clients provides that level of professionalism that frankly they really want. At the end of the day, most of the folks that we work with are very comfortable working with buyer representation agreements or tenant representation agreements because it does truly define what is expected of the agent and really what's expected of that client. So again, it's been a standard of practice for us most of my career, and frankly, it's a standard of practice that most will adopt very quickly.
Perfect. Thanks, Scott. Buffy, I'm going to turn it over to you.
Okay, well, thank you, Brent. So first, I do want to highlight the strengths of the MLS. I know things are changing, but if you think that MLS is only about compensation, you are just not correct. Our MLSs ensure that we have reliable data and that we have access to that data. As has already been pointed out by Scott and Brent, the ability to be able to have an aggregation of data in one place that is easily accessible to agents that provide the information that they need in order to be able to do their day-to-day business is priceless. You really can't put a price on it, and that's what our MLS does for us. Our MLS creates connections between agents, and that networking ability is not going to go away with this change. And then finally, our MLS allows all members, regardless of their business model, to thrive. It evens the playing field by compiling housing information into one place so that that information is the same whether you're a one-person brokerage or if you have 600 to 700 agents in your brokerage. Brent?
Thank you, Buffy. I heard you say a couple things that I think were really important there. Accurate, accessible, and I'm going to add the word relatively speaking compared to what commercial, really darn inexpensive for that accurate information. One of the most talked about changes with the implementation is the exclusive right to represent buyer, or what's commonly referred to as the buyer rep agreement. I'm going to direct this one to Buffy, one of our instructors for what is actually one of the most popular classes we're currently offering at Columbus Realtors, the buyer representation, the new landscape. That class is actually taking place downstairs right now. I know we were talking to a couple folks who had a conflict, whether they wanted to be on the webinar or they wanted to attend the class. So we have about 900, just shy of 1,000 registered for the webinar, and we have 125 members downstairs. So we're touching really about over 1,000 members right now, member touches from Columbus Realtors with some information. So Buffy, can you give us a brief overview of that class and explain why it's a good idea? And we have one coming up on September 19th.
We do. So what the class basically does is it outlines in detail the two changes. So the one obviously is that compensation will no longer be offered on the MLS. And then number two, that the use of buyer broker agreements are mandatory going forward. And so in the class, we actually do share with the participants the questions and the information that they can provide and give to their seller clients and their buyer clients, and then also the conversations the agents should be having with one another related to the changes. And then we do also offer a pretty robust opportunity to provide questions that we answer. And if we can't answer a question in that class, we follow up immediately afterward with the participants to make sure that they have everything that they need to be able to perform and to do their business. As far as the September 19th class, I would encourage everyone to sign up, all 9,600 of you, at some point to get in here, because at that point we will have been about a month into the changes, and I'm certain that there will be things that we will have learned as a result. We will be able to share best practices, and we'll know more about how we are all going to do this together. And obviously we would share any new changes, forms, and guidelines during that training.
Thanks, Buffy. We're going to dive into a couple key items here, and some of these you might sit and think, these are redundant. We're going to cover one now that I think we're going to cover again in a little bit, but that's because these are probably the most common questions or statements that we hear, some of which are inaccurate, and we want to make sure we portray that accurate information. But a question I know that I get asked often, or I've heard quite frequently is, can buyers and buyer brokers rely on an offer of compensation that was on the MLS prior to the effective date of the MLS policy changes? Let me put that in layman's terms. If there's an offer of compensation in the MLS today, can I rely on that tomorrow if I go into contract, tomorrow or after? Let me be clear. If the sales contract is executed before the MLS policy change, which is tomorrow morning, the buyer broker should be able to rely on the offer of compensation even if it is after closing, if closing happens after tomorrow. If a sales contract is not executed, if you're not in contract before tomorrow, the offer on the MLS will not be valid. Buyer and buyer brokers may want to protect themselves in writing with the listing broker or seller through a broker agreement or by including the offer of compensation in the sales or purchase contract. This is not legal advice, but simply printing off hot sheets tonight before compensation fields are removed will not solidify buyer-broker compensation moving forward. It must be part of the contract.
Thanks, Brent. Something else that we've heard is that realtors are at a disadvantage moving forward because they're bound by buyer rep agreements while non-realtors aren't. Ohio recently passed House Bill 466, which requires all licensees to enter into buyer rep agreements for the protection of all consumers. This will put everyone on an equal playing field. House Bill 466 will become law on October 24th. While we will still enforce these per the settlement, these will be required by law come October 24th, and failing to secure a buyer rep agreement could be in violation of Ohio Division of Real Estate and Professional Licensing.
Thanks, Jeremy. We're going to transition a little bit to forms here for a minute. Since March, our staff and volunteer leadership have been working tirelessly to prepare for many areas. One key area has been our standard forms, and I want to take a moment to thank our Executive Vice President, Kathy Elliott, and our Standard Forms Committee. You all have done yeoman's work. It is incredible. I think you usually meet maybe once a month or every other month. They are meeting nearly every week. Starting when the settlement was announced in March, we knew that we needed to provide a member resource and a member benefit. So those of you on the committee, which does consist of several industry attorneys, a lot of our members, I just want to take a moment and say thank you. We have several new and revised forms that we want you to be aware of. But before I turn this over to Buffy, I do want to make a couple clear comments about forms. We know that many brokerages, some of you as brokers have even reached out to us, and agents have received third-party forms off the website. You're getting off the internet. You're getting forms elsewhere and want us to review them. You've asked for our opinion. You've asked if we have an opinion, if they are compliant, and quite frankly, even to have counsel review them for you. Our forms, the Columbus Realtor, the association forms, are a tool in your toolbox. They are voluntary. They do not have to be used. We provide them as a member benefit. However, we do not have the ability to review, to provide input, or legal advice on forms that are not association related. We're agnostic and encourage you to do your due diligence. But again, we provide forms based on our committee and legal counsel recommendations.
So the first form we're going to talk about is the exclusive right to sell listing contract. The listing contract that is provided by Columbus Realtors has undergone some revisions, and I would direct you after this to go to your member portal and to take a look at the form. There is an annotation for Clause 2, because that is a change that was made to the listing agreement. And that annotation explains how in Section 2, there is a separation between the compensation that is paid to the listing broker for their services in the listing and selling the property on behalf of the seller from the compensation that the seller is willing or permitting to be paid to a cooperating buyer broker. So in the past, a seller would agree to pay the listing broker an amount, and then that listing broker would offer to share a part of that amount with the buyer broker. Under this new form, the compensation that the seller agrees to pay their broker, the listing broker, is intentionally separated from the compensation that the seller agrees to a cooperating buyer broker, so that there is further transparency in terms of who is paying whom. The total compensation that a seller would be paying at settlement would be the combination of the amounts in Section A and Section B of Clause 2.
Okay, earlier you heard Buffy go into detail about buyer rep agreements and really about the buyer rep agreement class. Another thing you should be familiar with is this additional non-exclusive right to represent buyer agreement. Completing either document with your client will place you in compliance with the new MLS rules that are going into effect tomorrow. Another form we are offering is the buyer broker compensation agreement. This document can be used when a listing brokerage or a seller are entering into a compensation agreement with a buyer brokerage. All of our forms can be easily accessed by logging into the member portal, including a forms toolkit that staff has prepared for you. So look for that if you can. Our standard forms committee is also looking into potentially adding the following forms: a termination of buyer agreement, an unrepresented buyer form, and an addendum form for the buyer representation forms. So keep a close eye out for all of those forms if you can.
Another important addition is a standard clause regarding buyer broker compensation. This clearly states that the parties acknowledge that the following broker is involved in the transaction on behalf of the buyer and that no other brokers are involved on behalf of the buyer.
Thank you all. Before we get to answering your questions submitted to us, I want to address one specific topic, which is called quote-unquote class notice. This is specific to, in referencing the class action lawsuits. So a class notice is a court-approved process through which members of the settlement class, home sellers, who sold a home during the eligible date ranges, the home was sold on the MLS anywhere in the United States, and a commission was paid to a real estate brokerage in connection with the sale of the home. So anyone who met those criteria will be informed about NAR's proposed settlement of the Sitzer-Burnett case. Notices will be distributed by mail, so think those postcards you may have seen previously, and electronically. The class notice informs class members, again, those who meet those criteria or who have met those criteria, of their rights, their options, and deadlines to exercise those rights and options under the proposed settlement. So consumers in Central Ohio have already received, we believe have received, a notice regarding separate settlements made by other brokerages and brokerage firms. However, a new notice will be sent addressing the NAR settlement. It is important to underscore that the National Association, the Ohio Association, nor Columbus Realtors manages the class notice at all. We do not manage that process at all. You as Realtor members may receive questions from consumers, somebody you sold a home to or sold a home as a client. You should direct consumers to the settlement website, realestateCommissionLitigation.com, where they can find the relevant information. You may also direct them to call the settlement administrator. Those numbers will be provided on those notices. But you, the Realtor member, should refrain from further advising consumers on class notice at all. So we talked a little bit of legalese about class notice. I do want to talk a little bit about antitrust in general. So as we dive into some of this, Scott mentioned antitrust and what was going on, brokerage decisions a little bit. Anybody who's sat in a committee meeting or here at Columbus Realtors and heard a commission number or percentage referenced, we shut those conversations down quickly. We cannot have any conversations about compensation or commissions which could violate antitrust. More so, conversations about business models in general and how you advise your clients could also be a violation of antitrust. We take those incredibly seriously. So as Scott mentioned, many of the answers to some of the most often asked questions are decisions that need to be made by you, either the agent or talking with your broker. We get questions all the time. What am I supposed to do here? What am I supposed to do there? Can you tell me how to fill out this form or how I should advise my client here? Those are all brokerage decisions. Some of you love to get in the weeds, but we have to do our best to say those are brokerage decisions and not the association or MLS position.
That's a very good point, Brent. And we've heard your frustrations, and I would just tell you that we understand, but the association cannot involve itself in business decisions of brokerages. The association and the MLS have really two responsibilities. Number one, to remove compensation from the MLS, and then number two, to enforce the buyer-broker agreements, which we've been talking about for many weeks now, obviously. Before we get going into some of the submitted Q&A, this is a reminder that removal of mention of compensation from the MLS is your responsibility. The MLS will remove compensation fields, but references to compensation, are still on you. Starting tomorrow, our MLS will begin to search for keywords that mention compensation or commission, and as a partner adhering to our customer service mentality, we're going to remove any references that we find. However, this is not going to be foolproof, and you are ultimately responsible for removing references to compensation in agent-to-agent remarks, in documents uploaded to your listing, and you do need to not forget about those PDF documents. Incredibly important. Any mention of compensation in your listings through fields or documents will be considered a violation.
Thanks, Scott. I just want to hammer that home one more time, that it's ultimately going to be on you, the member. We want to be a good partner. We want to provide that customer service. We'll begin those word searches. But come Saturday morning, August 17th, it's ultimately going to be your responsibility to remove any and all forms of compensation or commission. So the final section of our webinar today, our conversation is going to be focused on the member-submitted questions. We ask you to submit questions that we could address, and y'all came through. You weren't shy. We won't be able to answer all the questions today, but we promise we'll get back to you through email if your question is not addressed. Again, quite frankly, some of those questions aren't questions that we can even answer due to you needed to speak with your broker, or if you're a broker, those are business decisions that you need to make. So, Jeremy, I'm going to start with you. It's probably one of the most asked questions. Am I allowed to list a company website in agent-to-agent remarks?
Good question. The answer is yes, but kind of no. So it cannot be a link to compensation in any form. So doing so would violate the settlement, and enforcement would take place. You may provide links or other information that allows brokers to contact each other, such as a company website. However, this may not be used to circumvent the prohibitions of making offers of compensation on an MLS to cooperating brokers or other buyer representatives, either directly or through buyers, or disclosing on an MLS broker compensation or total broker compensation. For example, an MLS may not allow MLS listings to have an embedded link to a website which, with a single click on the MLS listing, would immediately display an offer of compensation.
I would comment there, we're getting some anecdotal evidence or conversation. Y'all are getting pretty creative already. While you are trying to get creative, we have to enforce the settlement. So as we begin to see how this takes shape and your creativity, I think we're going to have to monitor that and address that if needed, if and when needed, but hopefully we don't need to. So my next question is going to be directed at Buffy. Buffy, can a listing broker require proof of a buyer rep agreement prior to showing?
So this is a somewhat complicated answer, but the key term here is require. We are not attorneys, and obviously this is not legal advice. However, it is not an agent's, a broker's, or the consumer's duty to enforce the settlement. It is actually the MLS's duty. And so the listing broker, in asking for proof of a buyer representation agreement, is different than requiring proof of an agreement prior to showing. Under the MLS rules, the listing broker still has the duty to cooperate. Ohio law is very clear that a licensee must protect and not disclose any confidential information of the relationship with a buyer. And so I think it's fairly safe to say that the terms of a buyer representation agreement are going to be considered confidential information of that client. Because of this, the buyer rep would have the duty not to disclose that information under the duty of confidentiality unless they have authorization from their buyer client to do so. The definition of an MLS participant was amended to remove any references to offers of compensation and to establish that a participant has the duty to cooperate, which I said just before, which means to share information on listed property and to make that property available to other brokers for showing to prospective purchasers and tenants when it is in the best interest of their clients. And so it's not a requirement.
Yeah, that's one that we would urge you to talk to your broker about. Again, that's obviously not legal advice, but that confidentiality requirement is something that should be considered moving forward.
Yep.
All right, Scott, I still have heard this at area association meetings, quite frankly, too recently, that sellers or listing brokers offering buyer broker compensation is now illegal.
And the answer to that question is that is simply not true, okay? Offers of compensation will continue to be an option consumers can pursue off MLS through negotiation and consultation with real estate professionals. The types of compensation available for buyer brokers would continue to take multiple forms, including but not limited to fixed fee commission paid directly by consumers, concession from a seller, portion of the listing broker's compensation, and compensation would continue to be negotiated and should always be negotiated between the agent and the consumers that they represent.
So it can still happen.
It can still happen. Yes, correct.
All right, Jeremy. This is one we get all the time. Y'all are getting creative. Facebook groups, websites. So what about all these Facebook groups? We know they've popped up here, and other websites who are trying to promote offers of compensation.
So my simple answer is using these groups is not advisable, considering these groups could be the focus of outside interest. However, it's not, against the rules. So, use it at your own risk. Be careful, really careful on social media.
Yeah, they're not against our rules, but it doesn't mean that they are a great idea.
Right.
Scott, what happens if my buyer rep agreement, so I'm working, my buyer rep agreement states that I am to be compensated more than what a listing brokerage is offering to compensate. Obviously, it'd be offered off the MLS if they were. But what if my buyer rep agreement states that I'm to be compensated more?
Short answer. That's a conversation that has to be had between the brokerage and the consumer. Again, it's a conversation that has to be had between the brokerage and the consumer.
All righty. Coming to you, Buffy. One that we get all the time. I actually ran into somebody at dinner a couple weeks ago, out having dinner. How are we handling concessions in the MLS? And specifically, how are concessions being handled in agent-to-agent remarks?
So sellers are still able to offer concessions, and they will for things like carpet replacement, water heaters, driveways, etc. They're still allowed. And they are specifically allowed in the settlement to be offered in the agent-to-agent remarks. However, please keep in mind that this is not a workaround to offering commission in the MLS. And if we believe or know that commission is being masked as a concession in these fields, we are prepared to address this quickly to ensure that our MLS remains compliant with the settlement.
Thanks, Buffy. I'm going to come back to you for the next question, too. Again, not to reiterate or highlight one question over another, but I think this is an incredibly important one as we move to tomorrow. For current listings, do modifications need to be made to exclusive right to sell listing agreements?
Okay, so if you have an active agreement, so whether that is a listing agreement with a seller or a buyer-broker agreement with a buyer that was signed prior to now, and it can be amended, or you can do a separate disclosure that provides for these words, that commissions are not set by law and that they are fully negotiable. That terminology has to be included and can be done via an amendment to the original listing agreement or buyer-broker agreement, or in the form of an updated or an amendment, an amendment form to have those things happen. So for clarity, if your current agreements don't contain the wording, commissions are not set by law and the commissions are fully negotiable, they must be amended or a separate disclosure must be provided beginning tomorrow unless your clients are already in contract.
Thanks, Buffy. And to add to that on the buyer rep side, too, that you must be fully transparent about how you're getting paid, and that cannot be open-ended. So it cannot say something to the effect of whatever the seller or listing broker is willing to provide. It must be clear of how a buyer rep. So two forms that if that's not in there, as Buffy's mentioned, it must be amended tomorrow or disclosure. Jeremy, can a buyer enter into multiple representation agreements? Can a buyer enter into?
Buyer. So the responsibility is on the buyer's agent to have a conversation with the buyer to determine if there are any active agreements, either exclusive or non-exclusive. So technically you could have a buyer with non-exclusive multiple.
It gives you an opportunity to have the conversation with the buyer.
It does.
Amen.
It needs to.
Amen.
Alrighty, Scott, coming back your way. For the MLS perspective, what is the process for our MLS auditing a buyer's agreement with a buyer's agent? So what I mean by that is, if I'm an agent, can I just email the MLS and say that I believe an agent is not using a buyer rep agreement?
Okay. So we intend to enforce the buyer's rep agreements much like we do exclusive right to sell and clear cooperation violations at this point. If you have a reason to believe that this is happening, you may contact the MLS and we'll begin the process. Any information a complainant can bring forward to validate that claim would certainly help staff in that enforcement. So make sure that if you are going to be submitting something that you may deem a violation, try to make sure that you have good information that it can help validate that particular complaint.
Perfect. Thanks, Scott. Jeremy, coming down to you. Am I allowed to have someone within my own brokerage? So if I'm out of town, if I'm an agent and I'm out of town or I'm tied up at a kids sporting event or whatever it may be, am I allowed to have someone within my own brokerage show a home for me? Or do they need a separate buyer's rep agreement?
That seems like that's a real popular question right now, and there's two parts to this. The buyer's rep agreement is for the brokerage. So the intent is likely covered, and an additional buyer's rep agreement isn't likely needed. The other part of this is, what about an agent outside of my brokerage showing a home for me? That one, bring that back to your broker. Ask them for guidance on that.
Perfect. Scott, coming back to you. If a seller or listing brokerage is offering compensation or not offering compensation, and that offering is less than what I believe my time is worth, so I'm working with a buyer and I believe that I should be paid more than what I believe what my time is worth, or what I charge for my services, what am I supposed to do?
Yeah, I mean, this one seems simple to me, but maybe it's not, I guess. but you have the legal, the ethical, and the fiduciary duty to show all homes which meet your buyer interests. Hard stop. Really, regardless of compensation offered or not offered by a seller or a listing broker. And that's just from my perspective, it is a hard stop. You owe them that duty to show them properties that meet their specific needs.
You cannot sort compensation and
Correct.
pick and choose what homes you're going to show. You have as Scott mentioned, a legal, ethical, and fiduciary duty to show all homes. So I think that's an incredibly important one to hammer there. Buffy, question we got is, do agents still need the Consumer Guide of Agency Relationship signed?
The short answer is yes. That is a state mandated form, and you still need to have that form signed.
Thank you, Buffy. Scott, coming back to you. If the seller or the listing broker offers a bonus or a financial incentive, in addition to the offer of broker compensation, can the buyer broker accept extra compensation?
And the answer to that is the buyer broker may not receive compensation for brokerage services from any source that exceeds the amount of the rate that is agreed to in the agreement with that prospective buyer.
Perfect. Thank you, Scott. Coming back to you, Buffy. We're going to go to my left here. You're right on screen. Does Standard of Practice 1616 prohibit the negotiation of a buyer-broker compensation in a buyer's purchase offer?
So no, it does not. A buyer can always ask their buyer broker to make it a term of an offer to purchase that the seller pay certain compensation to the buyer broker. Standard of Practice 1616 prohibits a realtor from attempting to modify the terms of a listing agreement through the terms of an offer.
Thanks, Buffy. Jeremy, coming back down to you. Can a buyer request the listing broker to pay compensation to the buyer broker? Or can a seller pay a buyer directly?
This is an easy one. It's yes to both. This hasn't changed.
Perfect. Scott, man, we're just going here in order. We didn't set this up this way, but here we are.
Yeah.
Scott, can a listing broker communicate offers of compensation on a broker website which has an IDX or VAL feed?
MLS participants may display offers of compensation to buyer brokers or other buyer representatives for only listings of their own brokerage. Or put another way, broker websites may not contain directly or indirectly offers of compensation from other brokers.
Thank you. So that's not just, you have to think about some third-party portals that also are brokers.
Mm-hmm.
We've constantly heard, well, we can put it on this platform or showing service or whatever. If they have an IDX feed, they are receiving their information from us. Therefore, an offer of compensation communicated through an IDX feed would be prohibited. Can a listing broker, Scott, I think I'm coming, no. Buffy, I'm coming down to you, sorry.
No worries.
Can a listing broker explain to a seller, that the buyer will know who is paying the commission?
Yes. So in Articles 2 and Articles 12 of the NAR Code of Ethics, the listing broker should explain to their client the benefits and the costs of various types of marketing. A listing broker should inform the seller about costs that the buyer will incur, how that buyer might react to those costs, and how the seller can market their home considering the buyer's cost. But a listing broker must not tell a seller that a buyer's broker will steer buyers based on the amount that that buyer or broker will be compensated.
We've hit that one a couple times. Jeremy, what additional provisions must be included in written listing agreements because of the practice changes?
MLS participants working with sellers must disclose in conspicuous language that broker commissions are not set by law and are fully negotiable. MLS participants must include the disclosure in the listing agreement if the listing agreement is not a government specified form.
I think we've had that one a couple times too already. So, all right, Buffy, coming back down this way.
Yes.
What provisions must be included in the written buyer agreement?
So written agreements must include the following: a specific and obvious disclosure of the amount or rate of compensation that the participant will receive, or how this amount will be determined, to the extent that the participant will receive compensation from any source, so buyer, seller, or other. Number 2, the amount of compensation in a manner that is plain or evident and not open-ended. Number 3, the term that prohibits the participant from receiving compensation for brokerage services, from any source that exceeds the amount or rate agreed to in the agreement with the buyer, as Scott referenced earlier. And then finally, there needs to be a clear statement that broker fees and commissions are not set by law and are fully negotiable. You will hear that over and over and over again.
Yes,
Not
ma'am.
set by law, fully negotiable.
The next 2 questions are questions that we get frequently, but we have taken them directly from facts.realtor. We will talk about facts.realtor at the end. These are incredibly important. We're going to read them here. You won't see them on your screen, but you can find these answers in writing on facts.realtor. So Scott, I'm just going to begin with the specific question here. The practice change requiring written agreements with buyers is triggered by 2 conditions. It only applies to MLS participants working with buyers and is triggered by, quote, touring a home. What does it mean to be working with a buyer?
Okay, so the working with language is intended to distinguish MLS participants who provide full or limited brokerage representation or services for the buyer, including transaction brokerage, such as identifying potential properties, arranging for the buyer to tour a property, performing or facilitating negotiations on behalf of a buyer, presenting offers by the buyer or other services for the buyer from MLS participants who simply market their services or just talk to a buyer, like an open house, or by providing an unrepresented buyer access to a house that they may have listed. If the MLS participant is working only as an agent or subagent of the seller, then the participant is not working with the buyer. In that scenario, an agreement is not required because the participant is performing work for the seller and not for the buyer. Authorized dual agents, on the other hand, work with the buyer and the seller. A written buyer agreement is required prior to a buyer touring a home. An MLS participant working with a buyer can enter into a written buyer agreement at any point, but must do so by no later than prior to the buyer touring a home, unless state law requires a written buyer agreement earlier in time.
Again, that is specifically off realtor.com or facts.realtor. So if you want that defined in writing for you, you can find it there. So Jeremy, Scott just talked a lot about working with a buyer and touring a home. What does it mean to tour a home?
Brent, written buyer agreements are required before a buyer tours a home. Touring a home means when the buyer and or MLS participant or other agent at the direction of the MLS participant working with the buyer enters the house. This includes when the MLS participant or other agent at the direction of the MLS participant working with the buyer enters the home to provide a live virtual tour to a buyer not physically present. And a home means a residential property consisting of not less than 1 nor more than 4 residential dwelling units.
Thanks, Jeremy. We talked about redundancy earlier, so we're going to hammer another one again. Scott, should active buyer agreements entered into before MLS policy change tomorrow morning be amended to make sure any compensation is not open-ended or is objectively ascertainable?
Yes, we have covered this several times. MLS participants working with a buyer after the effective date of the policy should take steps to ensure that the buyer has agreed to the necessary terms required by the settlement agreement.
Thank you, Scott. Buffy, I'm going to come back down to you. If an MLS participant, we're talking open houses here.
Okay.
If an MLS participant, if a realtor hosts an open house or provides access to a property on behalf of the seller only to an unrepresented buyer, so let's put that in layman's term, somebody comes through your open house that you are holding open for your seller, are they required to enter into a written agreement with those buyers touring the home?
No. So in this case, because the MLS participant is only working for the seller and not the buyer, the MLS participant does not need to enter into any type of written agreement with the buyer.
Okay, so as we close out, we want to reiterate a couple of key items, and really the first is related to timing. These changes all begin at 8:30 a.m. tomorrow morning. Columbus Realtors is simply in charge of enforcing the provisions within the settlement, and this doesn't change your duties required under Ohio law or the Ohio Division of Real Estate and Professional Licensing. Many of the questions we're getting truly are brokerage and business model related, or can be addressed under facts.realtors. So please reference that if you need to. As we navigate these uncharted waters, we may need to add or amend rules or policies to continue to be in compliance of the settlement. We know some members are going to continue to get creative, but rather than find a workaround, we have a duty to comply with not only the spirit, but the intent of the settlement.
Thank you, Scott. As we begin our compliance, I do want to address one thing. We did not sit here today and tell you as MLS participants or subscribers where you are allowed to list compensation. That is not our job. That is not the enforcement of the settlement. We told you where you cannot list compensation. It cannot be in the MLS. It cannot be in VAL or IDX feeds. You cannot list it on, have another broker's listings of compensation on your website. Yes, you can have yours. A lot of you keep asking, is this permissible? Am I allowed to put compensation or list compensation here, X, Y, or Z? Our job is to enforce the settlement, and it cannot indirectly or directly be part of the MLS. So as we begin with our compliance of the settlement, please know we're truly going to come at this from a position of understanding. I talked to our team about this today. These changes mark a shift in our industry. We have a duty to help educate and to train and to support you, our members. We are not going to bring a hammer, but we have to enforce the intent and the spirit of the settlement. If and when violations are found, we are going to start by trying to contact you with a phone call. That is new. Typically, you just get an email saying, here's your fine, here's your violation, pay it or else. We are moving away from that model. Our entire team is here to help provide you the best service possible. We have staff available by phone and email this weekend. So we have our teams working this weekend to support you in the transition, to support it as smoothly as possible. I just want to thank you again for joining us today. We have over 1,000 members that we're talking to just today. We've had tremendous participation from each of our webinars this summer, and that shows how much you truly care for our industry.
Okay, before we conclude, we have two very important announcements. First, we mentioned Facts.Realtor several times, and if you haven't taken the opportunity to go there, you really need to spend the time to go there. This page has extensive information that is incredibly helpful. A summary of the practice changes, you'll find that there. An extensive list of FAQs, and some of them we've even covered here today, but even a much deeper dive. A guide for brokers, a guide for home buyers, a guide for home sellers, the Window to the Law video series, which has garnered nearly 300,000 views already, in a series that I think you and your brokerages should take time to view. And last, we want to take the sustainability and value add of this organization and our membership extremely seriously. We're looking at all aspects, debating from within what the future looks like. Before our board of directors, next week we will be putting together a proposal from a local public relations firm to begin the process of a prolonged multi-year campaign highlighting the value of our members and the services that you provide. And I am confident in these efforts. And I want to thank all of you for taking the time out of your day to join us today. So thank you for being here.